morning. We look forward to discussing FIGA claims. I know when I was a litigating attorney, there was some mystery to FIGA claims, and so I want to make sure that we kind of go over all of that and discuss those things with you. I also wanted to kind of, in addition to thanking you for joining us this morning, wanted to let you know that every attendee, if they email us, will get a packet not only of the PowerPoint, but also of a FIGA fact sheet, frequently asked questions, also all the relevant statutes. So this is something that if you just wanted to sit back and listen and observe and maybe take some notes, you have the confidence to know that you will have all of the materials that we go over. The other thing is that, when we discuss FIGA, it's a statutorily created entity. And so there are no quote unquote secrets per se. There's just navigating the statute and kind of understanding and having some attention. So one of the things that, we've decided to do at our firm is focus on these claims. And again, I remember as a litigating attorney, if I had, 90 files and 10 of them were FIGA files, those would often go by the wayside. So we want to clear up any mystery regarding that. So, let's get started. So here's what you could expect today as an outline. One is a general overview of why carriers are going insolvent, or some of them have gone insolvent. What is FIGA? How does FIGA affect claims? So claims that have not yet been made, claims that have been made, claims that are in litigation, claims that have been settled, but their attorney fees. So kind of each different phase of, how FIGA affects claims. And then finally, how our law firm may be able to help you navigate the FIGA process. My name is Winston Taitt. I founded Taitt Law in 2017. I began property damage in 2011. Began practicing here in Orange County as a public defender in 2007. On the screen is my personal cell phone, my email, and the logo of the best law school in the state of Florida, of course. I'm assisted by my boss, the managing partner, Sharon Freeman. She does both construction litigation and first-party property damage, and her information is also on the screen. And then finally, Doug Wall is a partner at Taitt Law, the newest member of Taitt Law. He's a board-certified construction attorney, which is a significant acclamation. It's incredible to get that board certification. I think it's around 5% of attorneys are board certified, so it's a great distinction for Doug, and his information is also on the slide. So this is a big question, and obviously there's a lot of different answers to why carriers are going insolvent. But one of the things I wanted to point out is that since FIGA's inception, 322 carriers have gone insolvent, and they've gone insolvent. Healthcare insurance companies have gone insolvent, property damage, auto, general liability carriers. So there is a certain narrative that, hey, we have a crisis, an emergency, and there are property damage carriers going insolvent, or property carriers going insolvent. But let's take a wider view of that and look back and say that 322 carriers in all different things have gone, in all different insurance markets have gone insolvent. And another significant thing is that we're getting larger and more frequent storms. And a lot of people will point out that there haven't been large hurricanes in the state of Florida. One, I don't know if that's accurate, but two, you got to keep in mind that if you're a carrier who writes in both Louisiana and Florida, if Louisiana gets hit with a ton of big storms, that's certainly going to impact your Florida business. And so we'll go on to the next slide and kind of look at, there's a narrative that's saying, hey, it's the contractors and it's the attorneys that are causing rising premiums and insolvent carriers, but really it's just free market business. I mean, you look at a company like Lighthouse Insurance Company, wrote 150,000 policies in Louisiana in 2020 and got dinged with Hurricane Ida, and they're already insolvent in Louisiana. So Louisiana does not have attorney fees. There are no statutory attorney fees. There are no incentives to litigate. And in Louisiana, you have numerous carriers going insolvent. So again, when you're looking at why carriers are going insolvent, I think you're looking at several things. Free market. So you have businesses that have more liabilities than assets. That happens in business, and that can't be legislated out. There's no legislation that can possibly stop a business from having more liabilities than assets. You have larger and more frequent storms throughout the entire Southeast, and you have carriers who are writing in multiple states, and that impacts Florida. And so it's not as simple of an issue as simply there's attorney fees and there's litigation. So I think those are some important things to consider. And we'll go into the next slide. And one final point on this, right before we jump into FIGA, is that there is a push, and we'll talk about it a little bit at the end. There's a special session beginning on May 23rd. And if what you're really looking at is extensive legislation that's been passed in 19, extensive legislation in 21, we don't know that there's any legislation that's going to stop a company who's performing poorly. I mean, there are companies who are thriving in the state of Florida, who's making a ton of money. And so the fact that we're going to write a legislation simply to help the companies that are failing, in a large part because of the multi-state risk they have, our position is that we don't need more laws, potentially the enforcement of the current laws we have at a maximum. But with that kind of brief background, we'll go into the real details and the nitty-gritties of what FIGA is and how it impacts you.
Yeah. And, one of the questions that a lot of our clients ask is this a new thing? These carriers are going insolvent. We're hearing about all of these insolvencies, FIGA taking over. And, is this a new problem? And the short answer is no. So big storms and storm seasons often weed out insurance companies. One of the most prevalent examples of this was Hurricane Andrew back in 1992. That storm resulted in over 25,000 property damage claims and caused $27 billion in damages. That storm alone caused the insolvency of 10 insurance companies. So now we have lower insolvencies proportionately, despite having some of the most damaging storms in the last 10 years. So carrier insolvency is nothing new, but it is still important to understand FIGA. And so what is FIGA? In short, FIGA is the Florida Insurance Guaranty Association, and we'll talk about what it is and also importantly, what it is not. So FIGA is an entity that was created by legislation to handle the claims of insolvent property and casualty insurance companies, along with other types of insurance companies, particularly in the state of Florida. So FIGA is required to settle claims in accordance with the Act, the policy, and Florida insurance laws in a timely manner. Most importantly, FIGA is the safety net for homeowners who have valid claims with an insolvent carrier. If it wasn't for FIGA, these claims would not get paid as soon as a carrier goes insolvent. FIGA is not an insurance company though, and it's also not a party to the policy of insurance. And so how we handle these claims changes slightly because they act as a guarantor rather than a party to that contract or policy. So when does FIGA come into play? When a Florida insurance company goes bankrupt, FIGA is called upon to step in to protect Florida policyholders. Like we were saying, it's that safety net. FIGA's work begins after a state court has entered an order of liquidation and the insurance company is declared legally bankrupt. At this time, the claims of the insolvent company are then transferred over to the Florida Insurance Guaranty Association for review and handling. So FIGA is a nonprofit organization and it receives funding from three main sources. So the first one is the estate distributions from the now bankrupt insurance company. Second is investment income. And the third are assessments levied on insurers based on the dollar value of policies they've underwritten. It's sort of similar to how employers have to pay unemployment insurance. Insurance companies in Florida have to almost pay for insurance. So they pay for FIGA and help fund that program. Payments are made on covered claims to insureds and claimants, and claims through FIGA must meet a strict set of criteria established by that law and the terms of the insurance policy in order to get paid. FIGA covers claims for losses that occurred either prior to the date of liquidation or within 30 days after the order of liquidation, unless the homeowner replaces the policy prior to the 30 days expiring. So it's also important to note that FIGA refunds any unearned policy premiums. They provide that prorated refund back to the homeowner, and covered claims between $100 and $300,000 are paid with some exceptions. So let's talk about how FIGA affects homeowners first and foremost. Homeowners can still file claims. So even if their carrier goes insolvent, they can still file those claims. The timeline of the date of loss and liquidation will determine against which entity that claim is made, and it's an important consideration. Additionally, homeowners can still file suit. So deadlines apply, including statute of limitations, to any lawsuits filed against the insolvent carrier and or FIGA, depending on that timeline. But suit can still be filed. It's important to know that some delays are expected when you're dealing with a transfer to FIGA, including delays related to claim evaluation by the now insolvent carrier, delays related to the claim transfer to FIGA, and delays related to judicial stays if claims are in litigation. It's incredibly important that homeowners obtain insurance coverage with another insurance company as soon as possible. So as soon as they find out that their carrier is going insolvent, typically they only have 30 days before their policy is canceled or expired. So they need to make sure that they get coverage as soon as possible. It's also important to have a legal team with an understanding of the FIGA process and the experience to push these claims to resolution. Now, how does FIGA affect contractors and PAs? So it's still super important for homeowners to file claims with insolvent carriers as quickly as possible. This is kind of like a first come, first served thing. We want to get claims timely filed and in queue. Earlier is always better. For claims going into litigation, we need our contractors and PAs to continue to provide all necessary documents as soon as they're available. This doesn't change. We still ask for the 3 main documents. That's going to be the contract with the homeowner, your estimate for services, and then the carrier determination letter. So we want to get those as quickly as possible. And we also ask that our contractors and PAs, just like everybody else, manage expectations with timing. Resolution with FIGA claims tend to be a little bit slower, but recovery is still on the table. FIGA also affects attorneys. So we put in the statute here, and that'll also be included with our post-attendee materials. So you can peruse that as you will. But attorneys' fees don't get paid by FIGA, so they don't get paid, period. Attorneys dealing with FIGA claims should be prepared to not receive fee awards or be paid fees, even on cases that have settled, and include fees in the breakdown. This is really important. Just to understand how FIGA affects every stage of claims resolutions and litigation. Because if you have entered into a settlement agreement with a carrier who then declares insolvency, goes bankrupt, and FIGA steps in, even if you have that settlement agreement that lays out indemnity and fee awards, you may not get paid those fees, even if you previously agreed with the carrier that they were due and owing. Similarly, FIGA is not subject to sanctions. So how do attorneys get paid? It really depends on the retainer agreement that attorney has with their client. That could be via contingency agreements based on a percentage of recovery, or foregoing fees entirely if the retainer is silent. I think everybody at our firm will agree that a small contingency is absolutely worth it to recover on claims that may take years to get paid, if at all, especially when you have pending property damage and need to mitigate and get your home restored as quickly as possible. So just putting the pieces together, it's even more important for homeowners, contractors, and attorneys to work together on cases where FIGA is involved so that we can maximize recovery under a claim and get paid fairly and as quickly as possible. So let's talk about the standard path for FIGA claims. First and foremost, we want to start at square one and check the date of loss. So if the date of loss is prior to or within 30 days after the date of liquidation, the claim can proceed. And why this is important is, again, the insurance policy is typically terminated after 30 days. So if the date of loss happens after the policy has expired or has been terminated, there's no carrier to sue. There's no carrier that's afforded coverage. And so it's important to look at that date of loss, and again, to make sure that your homeowners are getting covered as quickly as possible once they find out that their carrier is going insolvent. If it's a new claim, you file that with the carrier if it's within 30 days of the liquidation date, or you file it with FIGA if it's after 30 days. Suits must be filed within 1 year of liquidation. That's the statute of limitation for FIGA claims. And again, that's why it's so important to have attorneys who are familiar with FIGA, who regularly deal with FIGA claims, just to make sure that all appropriate deadlines are complied with. So for cases that are already in litigation, cases will be frozen via a judicial stay after the carrier goes into receivership or is declared legally insolvent or bankrupt. This typically takes about 6 months, sometimes a little bit longer. This judicial stay or freeze of the case gives the insolvent carrier time to pay claims with its assets and gives FIGA time to take over and evaluate the remaining claims. Once the judicial stay is lifted, the case is unfrozen, and the attorney will amend the complaint to list the Florida Insurance Guaranty Association as defendant instead of the now insolvent carrier, and then proceed with litigation. Again, because FIGA is not an insurance carrier, because it's not a party to that policy or that contract, litigation changes slightly, but again, that's why we want to have FIGA-focused attorneys handling these claims.
And that was an incredible overview of how FIGA impacts attorneys, how it impacts homeowners, contractors, and PAs. And again, most importantly is how do we help these homeowners who have paid premiums, who have valid claims, how do we help them get the benefits that are due and owing, even though the kind of journey towards that has kind of changed. As Sherry discussed, dates are extremely, extremely important. So when a carrier goes insolvent, you have 3 extremely important dates. 1 is the date of the order of insolvency. 2 is the statute of limitations to pursue claims through the legal system. And 3 is when the policy is voided. So we'll leave these dates up. And again, we'll provide these if you ask for it. But for example, Gulfstream, their statute of limitations is in 3 months. So if you had a Gulfstream claim, these dates would be extremely, extremely important. And the same thing, those dates are, we have those dates for St. John's and Avatar. There are other carriers who may or have gone insolvent. We don't have those dates currently, but we can provide those if that happens. And so these are some of the most recent insolvencies and the important dates, and why it's important to kind of make sure you have someone who's focused on FIGA specific claims, because this is not a process that can just go on like normal. There's different statute of limitations and the voiding of policies. And typically, how can we help? I mean, we have experienced attorneys, we have a FIGA-focused team. And I kind of say this again, anyone can really technically kind of figure this out. There are no secrets, it's statutory. But again, you need expertise, you need experience, you need diligence, and you need specialization to kind of see where the status of the claim is, the location of the file, is it in receivership, or does FIGA have it? What are the next steps to take in a timely fashion? And how to best prosecute your claim. We can't emphasize enough that this entire presentation is about getting homeowners paid on valid claims, that they're entitled to benefits in a really difficult situation when their carrier's essentially gone bankrupt. And so we can help contractors and public adjusters, who oftentimes send us and refer us cases. I think that's normal. Instead of abandoning clients who you may have just because they have an insolvent carrier, you can go ahead and continue to send documents and information as necessary. You look at law firms throughout the state. And again, there was a time when I sat down and litigated files, and I knew FIGA claims were not as profitable to me. And that sometimes leads to a little less focus. It's just kind of human instinct. If you're looking at one file, which is really going to be beneficial to you, and you're looking at another file that may not be, and also you don't necessarily know how to process those claims kind of fall by the wayside. It's just the reality. And so to have someone who focuses on that, I think is incredible. To have a dedicated team. Obviously, associating attorneys would receive any portion of the recovery made by Taitt Law. So again, for attorneys who are saying, hey, I have a ton of work, I'm getting paid on statutory fees, I don't need to, either I don't have a retainer that allows me to take a percent in litigation, or I just rather focus on the claims that get me paid, statutorily, we would, go ahead and begin an associating attorney agreement with your firms. You would allow us to service the mutual clients. You can focus your time and attention on non-FIGA claims, and you have the peace of mind of knowing that your clients are in good hands. We'll work to obtain the best possible results for your clients and obviously keep everyone updated during the process. That is, the kind of crux of what we have going on with FIGA. But this presentation is also takes place in part of a greater context, essentially. On April 26th, Governor DeSantis proclaimed that there would be a special session to consider some very, very significant items: property insurance, reinsurance, changes to the building code, the Office of Insurance Regulation, CRNs, and appropriations. This begins on May 23rd, but these are significant. So this is, this kind of list that you could imagine if, for example, there's a change to the 25% rule in the building code, or endorsements that are allowed through by the Office of Insurance Regulation. This is something that would impact us. And so we certainly, even though this is primarily a FIGA presentation, wanted to bring these things to your attention also. But as with any legislative session at this time, it's unclear whether there'll be any new laws passed or any current laws changed. Some special sessions are effective and change laws, and others don't have any clear resolution at the end. We'll keep our clients and referral sources updated about any new laws or regulations, any changes to current laws, and how these laws and regulations impact you. Last year, when SB 76 went into effect, we had a really important presentation on that, and we were able to prepare our homeowners and contractors and public adjusters for the changes. And we think we did a good job with that, and we'll continue to keep you updated with any additional legislative changes.